danger opinions. It has an exciting name. So what's a danger opinion? It's an application made by the minister that will enable the minister to deport a convention refugee or person in need of protection, contrary to international law in some limited circumstances. So the principle of international law that I'm talking about is the principle of non-refoulement, which is incorporated into Canadian law. And it basically means that a person cannot be removed from Canada to a country where he faces a risk of persecution, a risk to his life, a risk of torture, or a risk of cruel and unusual treatment or punishment. So a refugee, a convention refugee, or a protected person. So there are some exceptions to this principle of the non-removal of refugees, and these exceptions are what the danger opinion process is all about. So a protected person can be removed from Canada and returned to their country of origin in certain circumstances. And those circumstances are where it's been determined that that person is inadmissible for serious grounds. So for serious criminality, for organized crime, and for some that we've sort of touched on but we haven't talked about, security reasons and human rights violations. Number two, a removal order has to be issued. So that means the client has already gone through the deportation appeal process. That's all been done. The removal order is in place. And then either one of the two following. So for a refugee who is inadmissible on grounds of serious criminality, the minister must issue a danger opinion on whether the person constitutes a danger to the public in Canada. And then for people who are inadmissible on the other grounds, organized crime and security and so forth, the minister must issue a danger opinion based on the nature and the severity of the acts committed, or that the person concerned is a danger to the security of Canada. So what is a danger opinion procedure? The danger opinion process is a process in writing. So there's no hearing. The client should not wait for a hearing. It's not going to happen. And the danger opinion application, the process is kind of like a bunch of things all put together. It's kind of like a refugee claim, kind of like a humanitarian application. It's a bit like a deportation appeal, all kind of smushed together. CBSA will initiate the danger opinion process. It's not something the client can request. And it's not going to happen until after, like I said, the client's lost his permanent residence, he's lost any appeal he's had, and it's not going to happen unless the client's underlying status is refugee. So, like we've talked about before, many clients, they don't even know they have protected person status. That's something you're going to have to get them to find out. Often they have to go back to their parents and say, you know, how did we come to Canada? So they need to find that out. Another way they can find out is if they have been through the deportation appeal process, they're going to have a big package of evidence that they got from that, and in there, somewhere there will probably say how they came to Canada. It's often even like in a code, so they may not get it, but maybe you can figure it out from seeing it. It'll often have like a little CR, convention refugee.
Can I interrupt just one second?
Yeah.
Does it mean that this person continues with his protected person status even after acquiring permanent residence status for this person?
Permanent refugee is like the underlying status. So then on top of that, you can have a permanent residence status. So when that gets stripped away, the person's left with this underlying refugee protection status. And that means they cannot be returned to their country of origin. They're not permanent residents anymore, but they still cannot be removed because they've been determined to be at risk in their home country. So, and that's what this is all about, is there, at what point and in what way can we strip people of this protected person status and remove them to the country where it's already been decided they're at risk. So the way it's going to work is that CBSA will notify your client that CBSA has the intention to seek the opinion of the minister that this person is a danger to the public. And the client will normally be called in, and they're going to be given a really big, intimidating package of evidence with a cover letter that explains all this. and it's going to have evidence about their background, their status in Canada. It's going to have a lot of evidence about their criminal history in Canada. So if you're already on record, you're going to get served with a copy of that too as counsel. If not, the client will get it. So the client gets this, and the client is given an opportunity to respond in writing. And the timeline is really short. It's 2 weeks, 15 days. And that is nowhere near enough time to respond to this big, fat package of evidence. So counsel should always ask for an extension of time. And I mean, I've always got an extension of time, because I think basically there's a pretty high degree of procedural fairness afforded to the danger opinion process because of what's at stake. Because a protected person could be removed to the country where they're going to face harm. So you can ask for an extension of time to do an access to information request, because even though this package of information that you're getting is really thick, it's not going to have everything you want to see everything. So you can, I think Erica mentioned it, you ask for an extension of time to get access to information. You ask for 30 days, and when you don't get it in 30 days, you ask for more. And you just keep on referring to what's at stake and why you should get this extension of time. I've never not gotten an extension of time to make these submissions. But I think what's important is if you hear your client say, you know, I got a danger opinion or I got this big fat package of evidence, while you can get an extension of time, they have to make sure they get to a lawyer so the lawyer can make that request for an extension of time, because if not, that 15 days is pretty tight. If the client can't afford a lawyer to help them, I think the clinic will help them.
We're trying.
So the danger opinion process, it's a really lengthy process. There's this sort of flurry of activity at first. You've got 15 days to get all this evidence in. If you get an extension of time, you get the evidence in, and then you wait. There's like a really long wait. It can be a year, it can be 2 years. I think you mentioned maybe 3. You just will hear nothing. So what's really happening behind the scenes is that I think a manager at CBSA is reviewing everything you've submitted. And then that manager is going to make a recommendation to the minister. And they're going to bundle together their material that they gave you, all the submissions you make, plus a recommendation, and that's going to go to the minister. They prepare something called a ministerial opinion report. So this is everything. But before it gets sent to the minister, counsel is given another opportunity to make comments, to make further submissions. So that's probably the first time you're going to hear from them again. So maybe after a year and a half, you're going to get this ministerial opinion report. And then again, you're provided with an opportunity to make submissions. I think 15 days again, and I've asked for an extension of time only for that too. So then you'll update your submissions, and then you're going to wait for a final decision from the minister's delegate. So going back to what those submissions are going to say or what they're going to address, there's kind of 3 parts to the danger opinion. The first part is the danger assessment. So we're mostly dealing with clients with serious criminality, maybe organized crime, so we'll kind of talk about that. For the danger assessment part, counsel is going to prepare submissions that are going to address the question of whether the client poses a danger to the public in Canada, a danger to the security of Canada. So the fact that the client has criminal convictions, that's generally not enough to determine that person poses a danger to the public. What the question really is does this individual pose a present or a future danger to the Canadian public? So really, is this person like a potential reoffender, right? Like it's just going to pose an unacceptable risk to Canada, to the public. So when I'm doing submissions, that's the focus of my submissions, is try to anchor my submissions to this future-looking risk assessment, right? The likelihood that this person is going to reoffend in the future. So when I do that and focus on this future risk, I'm going to talk about the nature and the circumstances of the offenses committed. I'm going to talk about the sentences. I'm going to talk a lot about efforts at rehabilitation and likelihood of recidivism. So when I say nature and seriousness of criminal offenses, what's mostly looked at are violent crimes, sexual crimes, drug trafficking crimes. These are the ones that are generally considered serious in this context. Although I think there is case law that says that the crime does not have to be violent in order for the offender to constitute a danger to the public, but generally they're looking at the more serious ones. And another thing that has to be kept in mind when you do this is they can't just look at the sentence. They have to look behind the sentence, or what I'm going to argue, to see what actually happened. Right? The offense itself has to be considered particularly serious. So we have to check the facts of the case. There's a case of the federal court that's a good illustration of this. It was a man, amongst other convictions, he had a conviction for aggravated assault, which sounds serious. But when you actually looked at the facts of the case was, I think the man had bitten a security guard during a shoplifting attempt at a drugstore. But he was convicted of aggravated assault because he was HIV positive. And the federal court said that doesn't amount to a particularly serious crime, so not so much reliance should be put on that. And so that case was overturned. Something I'd like to do is to anchor my submissions again and look at the root causes of criminality, if I can find one. So does mental health play a part in the client's criminal history? Does substance abuse play a part in the client's criminal history? So if I can make this connection between one of those two things and criminality, then that gives me a way to argue that the chance of reoffending in the future is unlikely because of all the efforts the client's making to comply, to address these root problems that he's having. So that's where I'm going to look at maybe compliance with treatment plans from psychologists and psychiatrists, whether the client has done any addiction programs, maybe the client's done anger management programs. I can use these to sort of say, here's how the client is addressing the root causes of criminality, and this is why I think this client is unlikely to maybe reoffend in the future. And when I say that we get a really big package of papers, a lot of it is going to be like police occurrence reports, and there's gonna talk about withdrawn charges. There's gonna be pages and pages of stuff, and sometimes you have to be careful to watch for like an over-reliance on these police occurrence reports, maybe an over-reliance on withdrawn charges, or kind of like an improper weighing of charge when ultimately there's like no conviction. Really be careful of that and really wade through all these materials because really they shouldn't consider withdrawn charges, and they generally should not consider convictions under the Youth Criminal Justice Act. So you may have to point that out in your submissions, because that material, like I said, is all going to go to the minister. So you want to kind of have a go at it, explain why some of it is irrelevant, focus on what you think should be looked at. Because we have to look at behind the conviction at what happened, immigration lawyers can really benefit from help from criminal lawyers and materials that you probably have in your file from when you represented the client in the criminal context. So for instance, you might have some credible source evidence that we can use, such as pre-sentence reports, psych reports, things you may have gotten for sentencing, community service reports, those correctional service reports where they kind of do like they say what they think the rate of recidivism could be. They rank it. Those can sometimes be useful. Anything that I can use or that we can use that can indicate that the likelihood that the person continues to pose a danger to the public is not really there, or that helps us go behind the conviction and look at the nature of the offenses. Another thing that is really helpful when I talk to criminal lawyers is that they might know criminal law cases that can be really useful for me, because some of the language in a criminal law case can be really useful. Also, sometimes what I like to find out is what happened to the co-accused. I mean, that information can also be useful because it'll paint a broader picture of what the nature and circumstance of these offenses are. And sometimes, because I don't know this again, I'm going to call criminal counsel and I'm going to ask about the applicability of the Youth Criminal Justice Act and how that was all dealt with, because I can really benefit from that. So now I said that people will be served with this danger opinion package. They'll be called into CBSA, but this can all be started when your client is still serving a sentence. So if your client is serving a criminal sentence, I think the process now, what they recommend or what they say they're going to do in those policy manuals is they're going to try to initiate the danger opinion process 12 months prior to release. So on the one hand, that's really hard because it's really hard to get access to your client when your client's in prison to put together affidavit evidence, to get everything together. But also it can be kind of good because sometimes clients will have really good access to programs when they're serving their sentence, and I can sort of say, okay, have you done this program? Can you get me proof of this program? And I can use that. But yeah, that can be kind of difficult. You're definitely going to get in touch with family members because they can also help you with some of this. They might have paperwork that the client doesn't have. So in this whole danger opinion process, the person concerned does have some other rights that you can do. They have the right to cross-examine anyone whose information the minister is relying on in the process. So say you look into this big package and you see something, something from a parole officer that talks about likelihood to reoffend when the majority of the evidence looks like the client is doing really well. I haven't done it, but you can ask to cross-examine that parole officer. You can challenge the evidence because you want to challenge it before it goes untouched to the minister's delegate. So I said there was 3 parts. That's the first part. That's the danger assessment. So the next part that you have to look at is the risk assessment. And this is where I said it's kind of like a bunch of applications in one. This is kind of like the refugee claim part of the danger opinion process. So the origin of the danger opinion process really is from like Section 7 concerns. We're going to be removing a person who's already been determined faces a serious risk of persecution in their country of origin. So we have to look at this. So the risk assessment, a past finding that the person is a convention refugee it's not sufficient to establish a present and future risk of harm. So just because that person is a protected person, it's not always easy to show that today, if they go back to their country, they're going to face a serious risk of persecution. Like often, people came with their parents and they got refugee status because their parents got refugee status. And now they're grown up and now they're facing removal to this country where, that whole initial refugee determination doesn't really apply to their situation. So it can be kind of difficult. So the risk assessment does look at all categories of risk, not just the sort of narrower ones that we look at in refugee. One thing that often is the case is that you can look at new things that have developed in Canada. Perhaps new risks have developed in Canada. I mentioned a client with mental illness. If mental illness developed in Canada, which you might see if they came really young and they're now like a young adult, I might be able to make the argument that if this mentally ill person is returned to their country of origin, they're going to be severely stigmatized because of how people in that country treat people with mental illness. Another argument you might be able to make is around addiction. How is a drug addict treated in their country of origin? How is someone with this number of criminal convictions treated in their country of origin? So you might be able to use what's happened in the country to say, hey, this person does face a risk. It's a new risk. This is their risk if they're returned. Or perhaps, what else have I done? I've done cases where people have converted. They maybe come from a Muslim country originally, but in Canada they're very westernized, and in fact they might have become Christians. Well, maybe that's a big problem in their country of origin. So that's a new risk. It wasn't why their parents originally came to Canada. It wasn't part of that original risk assessment, but it's a new risk for the person if they go back. Yeah.
I was thinking of a question. So I think you said before that the risk, or the danger assessment is purely paper.
The whole thing's purely paper.
But you said before that there was opportunity to cross-examine based on some evidence submissions.
Yeah, that's. I think that might even end up being in the context of judicial review, but I've seen that you can do it. I read some cases where you can do it. But the person is never going to go to a hearing in front of the person who makes the decision about whether they're going to stay in Canada or leave. It's made by the delegate of the minister delegate. It's a person that you're never going to meet.
So there's very little opportunity to test the evidence.
Yeah, so, I mean, you'd always want to use affidavit evidence for one thing, but yeah, it's all on paper. So when you're doing this risk assessment part, like I said, you're probably going to want to do a big affidavit setting out, what this person thinks is going to happen if they go back to their country of origin and why. You're going to want to put a lot of evidence about what's going on in that country, right? So a lot of reports from human rights organizations, anything that's going to support that this client faces a risk if returned to this country. So that's the risk assessment. And then part 3 is where you get to sort of raise humanitarian and compassionate considerations, because you're supposed to look at everything. So we've already touched on this, but here's where you want to talk about establishment in Canada. You definitely want to show family support, and again, get affidavits from family members, proof of family members here. Does this person have children? Again, best interest of the child is a really important factor to raise. How involved has this person been in their child's life? You can't just have children, you have to be involved in their life. You want to sort of set all this out. So you're going to end up with a really big package of evidence to sort of counter their really big package of evidence. And then you've got these 3 parts. You send in your initial submissions. They send you their report. You then send in your follow-up submissions. Often at that point, time's gone by, so I might just even use the fact that the client doesn't have any new charges and say, look, see how good this person's been this last year. That might be all I'm adding to that, really, but that is important for the danger assessment part. You want to check your what's going on in the country that you've alleged this person is at risk, and maybe something new has happened. Maybe you want to definitely update your country evidence because it's a year later, and now this whole package is going in front of the minister's delegate. You might just check in with your client. You want to find out what's going on. Any new developments on their home front? How are they doing with establishment? Maybe they've been working. Maybe they've just done really well. You want to bring all that up. I had a case once with a guy who the danger opinion process was initiated, and I think he was released. When he was released from detention at a detention review, he had a drug problem. And one of the terms, one of the conditions of how we got him out of detention was that he agreed to go to a residential treatment center for drug addiction. And he went to this program, and this wasn't just a little short program. Like the guy, I think it was for 4 months, and then he agreed to stay even longer. And he spent almost a whole year there, and he converted to Christianity, and we had these glowing reports about how well he had done at this treatment program, and he really turned everything around in a year, and he ended up getting accepted because they found that he'd done so much to mitigate the risk, and so that was a good case. And so really what's happening ultimately is balancing. You're balancing all these things.
Balancing, is there any standard law?
I think
is
it's
it
balancing.
Totally discretionary.
What's the idea of balancing?
Any reasonableness, or how is
I guess it's ultimately reasonableness. If you're going to challenge a detention review finding on judicial review, you're going to want to say that this balancing was unreasonable.
procedural fairness or anything that?
I don't think it's procedural fairness, but definitely reasonableness, right? You're balancing the danger to the public in Canada against the risk the person faces and any kind of other establishment, children, humanitarian arguments, and you kind of see which outweighs the other. So did the delegate do that in a reasonable way? That would be your question.
The kind of threshold, is it high, low,
Is it high? Well,
balancing all
by the
these.
time you get to the danger opinion, your client's probably got a really long list of convictions. This is not people who've done a few things. These are people who've done a lot of stuff. So that's often what you're starting with, is this really heavily weighed. Yeah.
I have a question about it. It almost happened to us once. I don't know if I can explain this, but we knew that the Border Services officer was going to bring forth the intention to request the danger opinion. Have you ever done, or is there any precedence of a kind of a pre-submission in the same way as you wouldn't
Like a
want them to
44
commence.
report?
Yeah, kind of like pre-44 report, putting in maybe if a lot of time has gone by.
I think
mention
I've
two factors and
found ways to
saying-
ask for some more time to put the whole thing off, just to try to,
Yeah.
like someone else said, like,
But kind
time
of like-
can be on your side, right? You want this person to be doing
Yeah.
really well.
Kind of like a stay, saying, look,
Yeah,
just give them
I've
well.
never
It's been
done
5
that
years.
actually. I've never done that. I think I don't always know when it's coming. I mean, if I know it's like a week or two.
Yeah,
It's
here
not
we
a
kind of knew
lot
it was
of
coming
notice.
because the border services officer said, oh yeah, he'll have 15 days, but didn't have the package ready, and so how are we supposed to
okay.
respond to that? And so we knew it was kind of
I
coming.
mean, I
down
guess
the
you
pipeline, so
could.
it
I'm not
was-
sure. I mean, you're going to need to be making such big, extensive submissions. I don't know if it would really help at that stage to make it. I mean,
Yeah.
you could, but it's going to eventually then be part of your whole package,
Yeah, that was
right?
kind of
Because would you
outside.
address everything? Would you address danger and risk and in your little
Yeah.
submission?
Yeah, and you wouldn't
Yeah.
actually know, so we didn't actually.
Yeah,
know.
yeah. I mean, you want to get your package so you know what you're responding to in a way. Yeah. I mean, danger ranges are hard. I mean, I've won them, but I've lost a lot of them. So, there is sometimes you lose one if they make a finding your client is a danger to the public, and that means that clears the way for that client to be removed from Canada. But some clients they can't remove them, right? They can't get a passport for them. Clients could be here for a long time, even though they are ready to be removed, just because of those logistics. And I have done kind of like a reconsideration, because time has gone by and this client has done some really good stuff. And so I've used that time to my advantage, and I've sort of almost sent in like a new danger opinion. And I think also you can ask to reopen a danger opinion, but that would probably be if like a principle of natural justice has been violated. So say someone did it, but they did a really, you saw what a previous counsel did, and it just to you, it just did not look adequate. You might be able to make the argument, or you might be able to get in there and sort of put the whole thing on hold and say, I'm now going to make more submissions. You want to really, like I said, there's a high degree of procedural fairness afforded to these, so I think you can use that to your advantage to, at the very least, get more time to do this. And time can be a positive thing in these cases, because hopefully your client got his act together and doing better. So I've done that.
I was also wondering about, speaker time. So in terms of you were saying, and that's been my experience too, we had one that was 5 years before it was decided. And how often I guess it would be a case-by-case basis, and like you were saying before, if there are some root causes like some substance abuse issues that are being addressed. But even with country conditions, how often would you update something? I don't know, I kind of have I've got instinct to let sleeping dogs lie with that.
I would kind of like let it lie and like max out on the time.
Yeah.
And then when I get the ministerial opinion report, it's like, okay, here's all of it. To make, I might have more of an impact. I don't know. Unless there's something really big I want to add.
Yeah.
Because I've never seen CBSA officer not make a recommendation and move it on to the next step. I don't think I've really seen that. They don't read your submissions and say, oh yeah, you're right. Okay. I don't think so. Have you ever seen that?
No.
They don't. So I would wait. I would like kind of use the time, make a bigger kind of statement about how well he's done and all this time. And yeah, I think so.
Right. Does anyone have any more danger opinion questions?
So just more of a comment, actually. Just going to say, thanks for mentioning about the privacy requests. That's really important, always across the board, not just in these matters. And I found that because really rehabilitation is a critical factor in this type of procedure, and any immigration types of procedures for criminals as well. That applying for privacy information from the prisons is also a good tactic for a couple of reasons. One is you get all sorts of rehabilitation information from the Correctional Service in Canada. There's reports being done every day on what they're doing at work, what they're doing in programming, what they're doing on the range. And if it's all good, that's great stuff. And you can sort of say, well, these are the experts, not you, the immigration people, but the correction people, your colleagues that are professionals in the prison area, and they all say these good. So
Yeah,
what do you thought?
yeah, definitely.
And also, they don't block out the same materials that the immigration people block out. So sometimes you
That's
get
true.
stuff
Sometimes we'll get this big stack of it all blacked out. So, yeah. Well, remember those? I'm not sure if they do them anymore, but before someone went off to do their federal sentence, they would send them in Ontario to Millhaven. They get these big Millhaven assessment unit reports. And that was all about someone's, likelihood of reoffending, and they gave them numbers, in terms of likelihood, not so likely, and sometimes that was really good. I don't know if they still do that, but yeah, those can be good. They can be bad, but they can also be good. Because they often happen at the beginning of the sentence, right before they're then sent. So, yeah.
And also, provincial jail privacy materials can be useful as well. Also, cutting across the information